is federal and state laws. Federal and state laws. I want to start off in federal and state laws talking about the Sherman Antitrust Act. The Sherman Antitrust Act is intended to eliminate price fixing. Price fixing, a good example of that would be property managers or landlords getting together in a certain area and unilaterally raising all their rates on the consumer. So the consumer didn't have any choice but to pay that higher rate. They could also do the exact same thing to the owners that they manage their property to. That would be illegal, and that would be an example of price fixing and would be illegal based on the legislation called the Sherman Antitrust Act. The next one that the chapter talks about and speaks to is something called block busting. Block busting is a concept where a broker would go into an area and would convince the people in the area, the owners in the area, that a protected class of people was moving into town and or into the neighborhood, and that somehow their entering into the neighborhood would have a negative effect on value, so that those people would list their homes with that broker. So block busting then is illegal, and it's an attempt for a broker to evoke fear in order to get them to list the home. Okay, so that's block busting. And the third concept I want you to know, we've got the Sherman Antitrust Act, we've got block busting, is steering. Steering is an example would be a broker taking a person or steering them to a certain part of town based on their protected class. For instance, if somebody, maybe you're picking somebody up at the airport who's Vietnamese, and you immediately drove that person to the Asian district. That would be an example of steering, and that would be illegal. So we want to be very careful about those three things. Now, to prevent these things, and so that people would know their rights, the government has evoked legislation that requires us to put a poster up in our office that defines the rights to our customers, the equal opportunity poster that must be placed. Also, you'll see these little houses, this little house logo. The equal opportunity logo has to be put on our cards and on marketing materials that you put out in dealing with real estate. Always remember, like we talked about in advertising, always advertise the property, never advertise the people. Okay? All right, let's talk a minute about the Civil Rights Act of 1866. Civil Rights Act of 1866 was the original legislation on discrimination that basically said all people should be treated like white people. Well, that legislation has progressed significantly over time, and in the Fair Housing Act of 1968, we added protected classes. Those protected classes were race and color, religion, and natural origin. In 1988, we added family status to that. In the book, it'll give 3 instances where family status is exempt. So there are 3 exemptions from that, and I'll let you look those up and find out what those are. You'll need to know those for the test and for your quizzes. All right, so you'll talk in this chapter some more about using credit reports and things like that, and I'll let you research that and explore that. I wanted to jump to Megan's Law. Megan's Law is the requirement for sex offenders to report their location of where they live. They are also restricted in where they live based on the distance that they are from daycares, parks, schools, and churches. So there is a database of where these people live, sex offenders live. And so that is public information, and you can look it up on the internet and find out what their offense was, what their name is. There'll be a picture of the offender, and you'll know where they're at, so that you are responsible or can be held responsible for placing people in housing near these people without disclosing it. That's the Megan's Law, dealing with sex offenders. There's 2 more things. The next one is lead-based paint. The effects of lead-based paint on human. It basically slows the development, and it's primarily affecting kids under 8 and particularly under 5 years of age. We mainly see a problem with chipping and peeling paint, and we see problems and risks during renovating property when we're sanding and then we ingest the lead through our nose or our mouth. You can get it that way getting into your bloodstream. It's lead is noted through a blood test to see if there's lead poisoning. The requirements on the landlord and the property manager are this. You have to fill out a disclaimer of any property that was built before 1978. In 1978, lead-based paint was outlawed in the United States. So anything built before 78 has to have a disclosure. That disclosure has three things. It discloses whether the property manager or the owner or landlord knows of any lead-based paint. Secondly, if you have any reports of lead-based paint. And third, your requirement is to give a brochure to the tenant that explains the risks of lead-based paint. So that's lead-based paint. The last thing is the Uniform Residential Landlord-Tenant Act. This is the requirements the court uses when determining what's right and what's wrong between a tenant and a landlord. So these are the documents, if you had to go to court, that would be used to determine if there was any guilt or any situation. Things like fair dealings, they're going to look at the way leases are done. It covers security deposits, it covers owners' obligations, owners' rights, tenants' rights, abandonment, fire and casualty damage, and those types of things. Well, that's a wrap. Again, as I always say, if you have any questions, be sure and contact me, and good luck.